those defendants, those individual landowners, all they want, and we can't stop that. But there's no need for them to be involved in the suit because those same exact issues are already raised by the defendants themselves. And that's part of what has to be shown by an intervening party, that their interests are not already being taken care of by the parties who are already in the suit. That's clearly, they can't meet that burden. MCAP can't meet the burden of showing that their interests are not being represented in the case, because they are. Scott Crosby has already raised the issues that MCAP wants to raise, and he has the full backing of MCAP in doing that, whether they're allowed to intervene or not.
Okay. Mr. Nolan, do you want to address Factor 4 again? Because Mr. Peoples has now moved to Factor 4 under 2401. And
sure.
Explain to the court again why MCAP meets the fourth factor.
Your Honor, MCAP meets the fourth factor because it brings a broader community perspective to this than do two individual landowners. The two individual landowners, Mr. Robinson and Ms. Fitzgerald, their primary interest is so that their land remains undisturbed. Those are important interests. But MCAP represents broader community interests, which is that this threat to the aquifer that 1 million people depend on for drinking water needs to be stopped. And that interest, Your Honor, which is a legally protected interest by statute, as we pointed out in our brief, is more than the individual interests of Mr. Robinson and Ms. Fitzgerald. Now, we're grateful that they are standing against this pipeline in this particular proceeding, but we can't rely on them to always stand against this pipeline. It's important for a broader community group to represent the broader community interests. Have I appropriately answered the court's question?
Yes, you have. And Mr. Peoples, I don't necessarily agree with your interpretation of 68-221-702. Let me pull it up again. I was looking at it a moment ago. Let me pull it up here. All right, as Mr. Nolan pointed out during his argument, TCA 68-221-702, which is part of Title 68, Health, Safety, and Environmental Protection. Chapter 221 is Water and Sewage. And then Part 7 is the Tennessee Safe Drinking Water Act of 1983. 68-221-702 is the Declaration of Policy and Purpose. And that statute provides, recognizing that the waters of the state are the property of the state and are held in public trust for the benefit of its citizens, it is declared that the people of the state are beneficiaries of this trust and have a right to both an adequate quantity and quality of drinking water. So this statute, while it may place the duty on the state of Tennessee to provide clean drinking water, it does say that the waters in the state of Tennessee are held in trust for the benefit of the public, and that the people of the state are clearly the beneficiaries. So it appears to me that the members of MCAP have an interest in clean drinking water, in the quantity and quality of the water, and that they are third-party beneficiaries pursuant to this statute. So if they have an interest in the aquifer, that they are beneficiaries of the waters of the state of Tennessee, that's pretty clearly set out in this statute, then why should they not be able to intervene in this lawsuit to protect a broader right, as Mr. Nolan has said? Certainly, Mr. Robinson and Ms. Fitzgerald are opposing the eminent domain, the condemnation of their properties, and they have very, very good lawyers to do that. But the court is of the opinion that at this time, MCAP has met its burden under Tennessee Rule of Civil Procedure 24.01 for mandatory intervention, as well as under Tennessee Rule of Civil Procedure 24.02 for permissive intervention. I think that MCAP was organized for the purpose of challenging the Byhalia's ability, which is a private company. I don't think that there's any dispute about that. Challenging their ability to utilize the Tennessee statutes and to come in, number one, and to exercise the right of eminent domain, and then two, whether or not the purpose that they intend to exercise that eminent domain would be for a public use or a public purpose. So I think they have a much broader interest in this lawsuit other than that of Mr. Robinson or Mrs. Fitzgerald. And while Mr. Robinson and Mrs. Fitzgerald may be able to protect their interests, there don't appear to be any parties at this time to protect the broader interests of the citizens of Memphis, of Shelby County, and any other citizens who depend on the aquifer to provide quality drinking water for its citizens. So I do believe that the members of MCAP are beneficiaries pursuant to the statute. I do find, number one, that their motion was filed timely in both cases. I do find that MCAP has an interest related to the property and the subject matter of this litigation. Number four, I find that they are so situated that the disposition of this lawsuit may impair or impede their ability to protect it if they are not involved in this lawsuit. And then four, that their broader interest in this lawsuit is not necessarily protected by the parties to this lawsuit, Mrs. Fitzgerald and Mr. Robinson. So for those reasons, I do believe that their petition or motion to intervene is proper, that the court will benefit from having their input into this process as the court contemplates, interprets, and construes the statutes that are at issue here. The court looks forward to having MCAP participate because I think that they will offer, I think they definitely have an interest and they need to be heard. And the court is pleased to some degree that they have stepped up and decided to intervene in this lawsuit. Because again, this lawsuit is not just about Mr. Robinson or Mrs. Fitzgerald. These are two individual landowners. And if I recall, we started out with 11 or 12 cases. Over half of those cases have gone away. They have settled. I don't know the terms of the settlement, but apparently the plaintiffs and the defendants in those cases reached a settlement in terms of taking or the eminent domain of those properties. and the compensation that would be paid. Now, I feel that it's important that members of the community have a voice in this lawsuit. This is a situation where there could potentially be a settlement, but MCAP will still be remaining, and MCAP will be able to litigate the issues, whether or not Byhalia has a right to exercise eminent domain pursuant to Tennessee statute, and if so, whether or not the project that they are proposing satisfies the requirement of a public purpose or public use. And the fact that they are opposed to the project, that's just one factor, but that in and of itself is not the basis by which the court is granting the motion. The court is looking at the factors that are involved in Tennessee Rule of Civil Procedure 22.01, and I've very clearly gone through those factors and find that they have met all those requirements. Now, as far as 24.02, which is the permissive intervention, I also find that that MCAP has met those requirements, that it's clear that the claims or the issues that are at stake here have a similar, that they have a common question of law or fact. So the issues are going to be very limited. I believe that their claims are very closely aligned with the claims that Mr. Robinson and Mrs. Fitzgerald have. And then factor 2, Mr. Crosby, what was factor 2?
Your Honor, what we look at is under 24.02, this court has the right to, or has a discretion to allow intervention, one, if a statute confers that, or, it's or, so it's not an and, or two, whether a claim has a question of law or fact in common. And once Your Honor, as you've already stated, has agreed with that, then it just falls to Your Honor's discretion. And that discretion is only reviewed on appeal if it is arbitrary, illogical, or unconscious, unconscionable.
Unconscionable. Okay. Okay, 24.02, upon timely motion, any person is permitted to intervene in an action when the statute confers a conditional right to intervene, or 2, when the movement's claim or defense and the main action have a question of law or fact in common. So the court has found the second requirement has been met, and this rule further provides, as Mr. Crosby has said, in exercising discretion, the court shall consider whether or not the intervention would unduly delay or prejudice the adjudication of rights to the original parties. Well, there's no prejudice here. As Mr. Nolan and Mr. Crosby pointed out, Byhalia certainly has the resources to devote to this case. There's not going to be any delay. The motions were timely filed, and this court has already set out a schedule so that we can move this matter forward expeditiously. And again, in exercising my discretion, I do believe that it's very, very, very important for the members of the community, especially members who are going to be affected, be able to have a voice in this lawsuit. And that it will benefit not only the citizens of Memphis or Shelby County, but because this is such a, as has been pointed out, it's a question of first impression. The court is not aware of any other case in Tennessee where we've had a private company coming in, exercising eminent domain. There does not appear to be any governmental agency working with the pipeline, and it's been alleged that the purpose is for a private purpose that is not going to benefit the citizens of Shelby County in any way. So I think that this is a very important issue, and again, the court will certainly benefit from having interested citizens present their perspective, their interpretation of the statute, and help the court arrive at the right decision. So that's my ruling in this case. Both the motions are granted in both cases, and MCAP will be recognized as a party in this case.